the Supreme Court came up with its verdict on the use of the smart card reader as it concerns the 2015 general elections, those who were at the receiving end of that verdict did not appreciate it. Now, in furtherance of the synergy between the courts and the lawmaking arm of our democracy, which is the National Assembly, the National Assembly has taken steps to harmonize that court pronouncement and make the smart card reader a legitimate and legal part of our electoral system. That is what we shall be talking about on the scale in this edition. Welcome to the program. I am Femi Okeowo. As we continue to sharpen all the edges in our democracy, the Electoral Act, which remains our guide for elections in Nigeria, must continue to be tinkered with. And the National Assembly knows that very well, particularly when it comes to areas of technological introduction into our electoral system. That has been amended, and now the electoral system must now accommodate the use of the smart card reader, which was supposedly an initiative of the INEC. Now it has a legal backing of the law. We have spoken to some lawyers who look at the usage of the Electoral Act, its amendment, and some of the introductions in the Act now. What's your opinion about what the National Assembly is doing and now that it's been accepted?
I want to say that confusion continued until the Supreme Court made its pronouncement, and to that extent that obviously determined the issue as to the legality or otherwise of the use of the card reader at that point in time. But now we are on a new slate, and a clean slate for that matter, and we now feel that 2 years moving on to the 2019 election, we must be sure as a people what we have to have on ground in order to be sure of the nature and the pattern of the election that we are going to confront come 2019. And happily, there are so many reforms going on, so to speak. The one set up by the executive, headed by the former Senate President Kenneth Nnamani, and then the moves being made at the National Assembly to make sure that the Electoral Act is tinkered with in the way and manner to reflect the reality on ground, and the way and manner that the 2000 election will pan out in a way, obviously, that will be in accord with the wishes of the people and reflect the consciousness of our people to a large extent. And ultimately, the whole move is towards ensuring that we have a credible, free and fair election, and that the purity and integrity of the election is not compromised, so to speak. So I think I'm in agreement with all the efforts being made, and I want to urge that we finalized everything early enough so that the training and sensitization and education enlightenment of the citizenry will take place sufficiently early enough so that people will know exactly what they are likely to confront come 2019. If we're able to put all this in place, I look forward to a very, very good election.
At that time, people thought that the Supreme Court should not have made that pronouncement.
Well, the Supreme Court's hand cannot be tied, so to speak. Again, it depends on the issues that were canvassed and the grounds of appeal that were obviously filed by parties. Incidentally, I was also part and parcel of that litigation, as the case may be, and to that extent, I knew from the onset and from all that happened, coming up from the tribunal and all to the Court of Appeal and so on, and so that issue was very, very cardinal and fundamental in the determination of the disputes that are raised, and to that extent, there was nothing that would have prevented the Supreme Court from weighing in one way or the other on the issues raised without necessarily failing to address the issue properly. So they needed to address the matter, and they did so.
We initiate moves, but do not back them with laws, because that pronouncement by the Supreme Court has now been justified with the moves that's been made to legalize the electronic voting system.
Well, the e-voting system is a move in the right direction at any point in time. And yes, I agree with you entirely that what is being done now by the National Assembly is to put a stamp of authority on the pronouncement of the Supreme Court to an extent. In other words, validating in form of legislation what the Supreme Court pronouncement was. So to that extent, we are now moving from public policy to statutory pronouncement or enactment, as the case may be. One can be deviated from one way or the other, but one is static in the sense that it is a legislation unless it is repealed. Now, what that means in effect is that, yes, we are given credence or lending credence to the Supreme Court's pronouncement by trying to validate that pronouncement in a statutory form. All I'm trying to say is that electronic voting is good, and we must look forward to it. But we must look forward to it within the context of our own peculiar environment. Why do I say peculiar environment? We must take cognizance of the fact that electronic voting must work with certain parameters in place. The issue of power, the issue of the enabling environment, and when I mean enabling environment, I must talk particularly about the level of literacy in a particular locality. Are we sufficiently literate enough in this environment to the extent that we can conveniently and comfortably embark on e-voting? I am afraid we are not. I am afraid we are not. We don't have that level of literacy. It is not simplistic enough for you to say you just press a button. You must have an idea of what you are pressing, and so on. When it is just to drop the ballot, we cannot even do it. So that is just my fear. But whether it's a dynamic move, it is. We are occasionally always in a hurry to adapt, adopt, and practice what obtains in other climes. A much more civilized clime. If we go historically, we must ask ourselves, at what point in time did America even adopt electronic voting? In their long checkered history of almost 200 and something years, at what point in time did they start electronic voting? And where are they in terms of their educational awareness and enlightenment as far as their democratic processes are concerned? I don't think we have gotten to that level. I don't think so. So my challenge is that, yes, it is a dynamic move, but no, we are likely to face the challenges of not having the environment that is conducive for such a voting to flourish. And what are we confronted with? It will create room for abusing the integrity of the pure process. It will create room for lack of purity of the electoral process. It will create room for possible compromising of the voting system, and obviously it will lead us to lack of free and fair election if not properly guided. But if we are able to pan it out in such a way that we can achieve all these other indices very well and clearly through enlightenment and what have you, I believe this is the way to go for the future. But there must be certain things that we need to put in place in order to address that.
Gladly, it doesn't seem that the e-voting will start immediately. It is the smart card reader that will start immediately in the 2019 election.
Okay, that's fine. Well, it also verifies what I'm saying, that yes, we may not be in a hurry to embrace e-voting. Yes. So let us see how the smart card aspect of it will work as a test or trial exercise before we can now move forward here.
As if to validate and justify the position of the Supreme Court in a number of cases during the 2015 general elections, the National Assembly has made amendments to the Electoral Act. What are your observations about these amendments and how far it can help our electoral system, particularly starting with the process of accreditation before we go to voting?
Well, the decision by the National Assembly to amend the Electoral Act is to bring in line the manuals or the guidelines of INEC, most especially when it relates to issue of accreditation. Before the 2015 general election, elections were conducted and accreditation were done on a manual basis. But in 2015, Independent National Electoral Commission introduced the smart card for the purposes of verifying a voter, who has already registered and has his name in the voters register. That does not mean that a person whose name is in the voters register and the smart card is unable to verify him, that does not mean he is not a registered voter. And that explains why the Supreme Court, in the cases of Rivers, Akwa Ibom, and Gombe, in the governorship election, decided that for the purposes of accreditation, you are not only to use the smart card, you are at the same time to use the smart card in conjunction with the voters register and incident report for the purpose of determining who are the people that are actually registered voters.
But now the amendment allows for the use. What does the amendment say now?
The amendment now is bringing the guidelines into the main fold of the law.
Okay.
Before it was a guideline.
Okay.
Now it is coming into the main legislation. That is the act giving the Electoral Commission the powers to use it as a matter of legislation.
Okay.
Because the Supreme Court said that if it is just in the mere guideline, you cannot say that you will only use the smart card and then jettison the voters register.
Okay.
Now the implication of the amendment now is that there is a likelihood that in the next election or elections that are likely to come, the smart card may I say, may be the only means of with which voters will be accredited.
If that happens, does that mean that the voters register would have been made in such a way that the smart card reader would take over the responsibility of the voters
That is the
register?
implication. If you legislate it and put it into the law, into the act, because we have to ask ourselves what is the intendment of the legislatures, the National Assembly. Their intention, by my understanding, is to ensure that anybody that the smart card is not able to capture in the process of accreditation is as well not registered. But in order not to disenfranchise voters, we have to ensure that the smart card is good enough, I say, to really capture the voters. Otherwise, we are likely going to have the same problem that we have, a legislation that may be observed more in breach than in compliance.
Okay. One of the other amendments is that Section 52 has been removed, or it has been added that e-voting can be done by INEC when it is suitable, or contrary to what Section 52 said that it's prohibited. What is the implication of that?
Well, Section 52, subsection 2 of the Electoral Act 2010 as amended prohibited e-voting. That is the way and manner developed countries, other countries of the world do their voting. Now, with the deletion or removal of the prohibited provision, that is subsection 2 of section 52, it means INEC now can, if it deems necessary, can go into the process of e-voting. The question is, are we ready to embark on the process of the e-voting? Because there is a wall of difference between e-voting and internet voting. We should not confuse the two. E-voting is what they do in developed countries, whereby you still go to the polling unit with your voter's card. You will be duly accredited. You will be given the ballot paper. But when you enter the polling booth, where you are expected to vote, there is a machine whereby you will vote electronically, and then the ballot paper will still be put into the ballot box. In the event of a dispute, because as you are voting electronically, it is counted automatically. Yes. Before the close of polls, you will have known the total results of the election. That is e-voting. But when there is a dispute as to the accurate number of those that voted by e-voting, then the question will be, how do we determine it? Then you go back to the manual votes, which are put into the ballot box. That is what they do.
So the two are done simultaneously?
The two are done simultaneously. And it is clear, and everyone within living memory should remember, anyone that is student or lawyer of electoral lawyer should know, in 2000 in America, when there was a dispute as between former Vice President Al Gore and President George Bush as to whether or not Bush had won the election, Al Gore asked the court for a recount of the ballots, those that were put in the ballot paper, because he had questioned the electronic votes as the scores of George Bush. So at the end of the day, the ballots were counted, but midway, because of the time constraint, not the time constraint, but the time limitation, they had to call it off. And at the end of the day, Vice President Al Gore said, because of the time and the finality, he considered not that he has agreed, but because of the time constraint.
So now, these amendments, you have been neck deep in electoral matters over the years. You think it will help the procedures?
Well, as far as I'm concerned, if we are to do it in the right way, it is likely going to help the procedure. But I must, with all sense of responsibility, sound a word of caution. Are we really ready for an electronic voting? Do we have the necessary equipment to do the e-voting?
And level of education.
And level of education, voters' awareness. Because voters, if they go in, those that are not educated enough, how will they be able to know with the machine? It's not like the ATM machine if you go in. A lot of people, even the educated people, when they go to take money, they normally ask people to assist them. So it is the same thing with the e-voting. So we need a lot of voter education. And secondly, we need people to be educated in the use of the electronic gadgets. And furthermore, we have to improve on the power situation, because polling units in Nigeria, you can imagine a country with 774 local governments, with hundreds and thousands of polling units across the country. Will we be able to cover the entire neck and breadth of this country? Because I must say, with all sense of responsibility, we have talked of registration of voters. We are to register voters using the data bank, as the Nigerian immigration are using their own data bank for the purposes of issuance of passport. But what did we have at the end of the day? mere laptops were used to register voters. And now you cannot say precisely where the actual or accurate number of people that are registered, even though if you go to INEC database or INEC bank, you are likely going to get after sifting. But so many people lost their registration through that process. So we must improve on the technology and the system. And government must fund if we are likely, if we are to succeed. Government must fund it, and the implementers or those that are to execute it must execute it sincerely. That is my opinion.
And lawyers do not look for loopholes.
No, you see, lawyers don't necessarily. Lawyers are not looking for loopholes. Lawyers are always there to ensure compliance with the law. If you don't comply with the letters of the law, the lawyer will ask you, you are supposed to comply with A, B, C, and D. You have complied with A, D, you don't comply with C. Then the lawyer will tell you, you have not complied with C. That is not loophole. The lawyer is talking of non-compliance. That is it.
These are lawyers who have been involved in electoral litigations, and so they know the loopholes. They know the areas where they themselves and their colleagues always look out for anytime there is a matter in court concerning elections. And let's hope that sufficient loopholes have been blocked in this election. And when we come to conduct the 2019 elections, let's hope that a number of areas that we experienced in the 2015 general elections would have been sorted out. Thank you for being part of our program today, The Skill. More issues are always on the desk, on the table for us to look at, and we shall not miss out on them as it helps to enrich our polity. See you again.